Current Issues and Upcoming Challenges, oferecido pelo Instituto de Blas e Parente. Se você está nos assistindo pelo YouTube, a transmissão será feita apenas em inglês, mas caso queira ter acesso à tradução simultânea para o português, você deve utilizar o link para a plataforma Zoom, que foi informada logo após a sua inscrição. A partir desse link, você terá acesso à nossa sala virtual e poderá alternar o idioma de transmissão no botão que tem um globo, né, no menu inferior do Zoom, que ele está denominado como Interpretation. As perguntas podem ser feitas em português ou inglês pelo chat, tanto no YouTube ou na caixa de perguntas e respostas no Zoom. So now, going back to English, I'd like to inform you that you can watch this webinar via YouTube only in English or by Zoom platform with the link that was informed after your registration. By Zoom, you can change the language from to Portuguese in the bottom located at the bottom menu of Zoom. It has a globe and it's called Interpretation. Moreover, you can leave your questions in the YouTube chat, or you can leave them on the Q&A box at the Zoom, both in Portuguese or English, and they will be addressed at the end of the webinar. So instructions given, let's get started. This webinar is brought by the de Blas Institute, de Blas e Parente Institute, and today we'll talk about agro patents, current issues, and upcoming challenges. It is well known that agribusiness plays a huge role in Brazil's economy. In the last 40 years, the production of food increased more than 36%, and in 2019, almost 50% of Brazilian exports were related to agribusiness products. So currently, Brazil is the fourth largest exporter of agricultural products, beyond the larger exporter of sugar, coffee, orange juice, soybeans, and the 30th largest exporter of corn. So along with this huge impact in the economy comes the need for constant innovation in machinery and process improvements to achieve a specific result, such as increased productivity, protection against pests or weeds, pesticide or herbicide tolerance, or the presence of a desired trait. So this leads us also to the use of high-end technologies such as genetic modification or even artificial intelligence. So today we'll have three very special guests to discuss the main issues and challenges for protecting such technologies. Our first panelist will be Mr. Nicholas Combs. Mr. Combs is an IP counselor at Corteva AgriScience. He holds a chemical engineer degree at the Arizona State University and a JD at the George Washington University, and he is a USPTO patent attorney. Prior to joining Corteva, former Dow AgroScience, Mr. Combs was an attorney at several law firms, and at Corteva, he's the responsible attorney worldwide for the cereal and commodity herbicide patent portfolios. His expertise includes managing defensive oppositions, re-examinations, and offense litigations in various jurisdictions, the settlement of interferences before the USPTO, the guidance of worldwide IP enforcement efforts, the orchestration of freedom to operate for products, negotiation, drafting, and review numerous licensing and research agreements, and the alignment of IP portfolios, focusing on patents and trade secrets. We'll also have the expertise of Dr. Barbara Engels. Dr. Engel is partner at Fleischer, Engels & Patent. She holds a PhD in biochemistry at Max Planck Institute of Biochemistry and became a licensed German and European patent attorney after working for several years in preclinical research for pharmaceutical companies. Her expertise includes patent applications, oppositions, and appeal proceedings, searches and opinions on legal validity and violation of IP rights, nullity and infringement suits, and employee invention law. And finally, we'll have Dr. Charles Romano. Dr. Romano is a senior patent agent at McKee Vorses and Seas. He holds a microbiology degree at the University of Massachusetts and a PhD in biochemistry at Harvard University. Dr. Romano has extensive experience in biotech patent preparation and prosecution, gaining in over 15 years as USPTO patent agency, representing venture-backed startup companies, multinational corporations, and university clients. Prior to that, he had a scientific leadership position at the agro, biotech, and pharmaceutical industry, and he is also a named inventor in 22 US patents. So I'd like to thank you all for being with us today and for sharing your expertise and your time with us. As spoken before, the viewers can send your questions either in Portuguese or English to the YouTube chat or the Q&A box in Zoom, and they will be addressed later. So for starting this great discussion today, I'd like to invite Mr. Combs. The screen is yours.
Thank you, Ludmilla. It's a pleasure to be here. So I am a patent attorney with Corteva Agroscience, and just kind of with that, today I'm going to be speaking on worldwide patent portfolio management. And as I was kind of putting this presentation together, Ludmilla had asked me to talk about issues both with prosecution and just management of the portfolio and some of the technology that's we're seeing in the agro business. And as I kind of put those together and started looking at those, especially with my experience with oppositions, there started to be some common themes. And that's kind of what I want to talk about today, is kind of looking at that a little bit from the client perspective. So if you're an attorney with an outside law firm representing agro businesses, you can kind of look at some of the things that they might be focusing in on and really be able to tailor your communication to them that way. Or if you are in-house, this kind of also serves as kind of a, maybe a little bit of a mental checklist. It's something that I kind of are some things that I tend to look at. And so here at Corteva Agroscience, we are the largest pure play agro business. We are based out of the United States. We are the result of the merger between Dow and DuPont. And let's go ahead and go to the second slide if we can. And so here at Corteva, our purpose is to enrich the lives of those who produce and those who consume, ensuring progress for generations to come. We are the resulting merger of Dow AgroSciences, DuPont, Crop Protection, and Pioneer Seed Company. And let's go ahead and go on to the next slide. And so as part of that, our aspiration is to design and deliver innovative, sustainable agro products and solutions. There are a couple things that we focus on. First, we try to help farmers improve their productivity of their operations, and we want to serve them in a way that they feel that they want to be served and create value for customers and society. And while doing all of that, being able to earn trust. There's a lot of information out there about agribusiness that, a lot of varying opinions, and so we want to increase that trust that's out there. Let's go to the next slide, please. And so Corteva Agroscience, this just kind of gives you a scale and kind of where we're based out of. We're based out of Wilmington, Delaware, and we have two major business centers in Iowa and Indianapolis. I am based out of Indianapolis. And then we also have regional business centers all over the world. We employ about 21,000 people in a variety of 140 countries. We have over 150 R&D facilities, and we have about 16,000 granted patents. We serve over 100 different types of crops and have over 10 million customers. And so kind of when looking at that, when looking at our patent portfolio and everywhere that we serve, one of the important things to consider is not only obtaining a patent in various jurisdictions, but also obtaining an enforceable patent in those jurisdictions. And as you can see, in the many countries that we are in, there is obviously a variety of patent law. And so that's kind of where I'm focusing this presentation in. Next slide, please. And so when kind of looking at worldwide patent portfolio management, it can be complex. It can, given the variety of laws. And when I kind of think of some of the major issues that come up in patent prosecution, the first one is the requirement to inform of material material to patentability. So like IDSs, there's requirements in the US, Israel, and India, and some other jurisdictions that way, and some other jurisdictions don't have that. Another interesting thing that informs patent prosecution worldwide is double patenting. Some countries have very lax laws, allow you to do things such as in the US, terminal disclaimers, and other countries have very strict requirements. With that, you also have the double play with restriction practice. In some jurisdictions, they're very strict on restriction practices, and other places are a little bit more liberal, a little bit more open. One of the things there that, at least from a US perspective, when communicating with in-house counsel, a lot of times I will instruct outside counsel, go ahead and file a divisional application or a continuation application. Sometimes in other jurisdictions, that might not have much of a distinguishing characteristic. However, in the US, that is key. The reason why is you can file a divisional only when there's been a restriction requirement. And what that does is that it stops the United States Patent Office from issuing a double patenting rejection. Whereas if you file a continuation application, they are not stopped from doing that. They're not prevented from doing that. So that's one thing to consider. The other one is support requirements. Dr. Engels will probably go into this a little bit more in her presentation, but when we draft worldwide, we not only want a patent in the US or Brazil, but we would like it worldwide. And some jurisdictions are a little bit more strict than others, and some are becoming more strict. And so when looking at that, we look at, written description, enablement, best mode from the US perspective, but as Dr. Engels will probably get into, there are European requirements of sufficiency, clarity, and original disclosure. And so when looking at that, and when we draft our patents, one of the things that we have to kind of consider is where are we going to file and which jurisdictions have those stronger requirements, and draft accordingly. And then finally, there's also novelty and inventive step or obviousness rejections. Those are handled differently in different countries. And so part of the issue with that is being able to have arguments and responses that we can use in other jurisdictions, but are consistent across many jurisdictions, so it doesn't seem like we are being inconsistent before one governmental body and another. And so when you take all that, that makes prosecution seem really complicated. But on top of that, then what now we have to do is look at post-grant proceedings, enforcement actions, and actions by other regulatory agencies. And that can complicate what we do when not only prosecuting a patent, but also with post-grant proceedings, which is I'm going to kind of more tailor this presentation on. Next slide, please. So just as kind of a brief overview, here are a couple ideal post-grant proceedings, and I'm kind of focusing on the post-AIA. The US law had changed from first to invent to first to file. So I'm kind of focusing on those proceedings that you can do. There are inter partes review, IPRs. There's ex parte reexamination, post-grant reviews, and you can also challenge patent in a federal court. There are other ones that are kind of going away, such as covered business methods that I didn't really think to get into on this presentation. But when you look at these ways of challenging a granted patent in the United States, there are many things to consider. They vary and they differ by not only who can file them, what patents are eligible, whether or not there's discovery, whether or not it's ex partes, whether or not someone can continue to file briefs on them. Let's go ahead and go to the next slide. So one of the things when we think of, at least as in-house counsel, when looking at post-grant proceedings outside the US, they typically fall into one of three categories. There are oppositions, re-examinations, and federal court actions. Now, your specific jurisdiction might have something different, or if you're a Brazilian attorney or in-house counsel liaisoning with someone in another jurisdiction, it's really key that although it might come under the title of an opposition or something similar, to really kind of understand what is required and what are some of the questions that maybe your client will have, or questions that you kind of need to preemptively answer for your client, or at least be aware that those questions are coming. And so just to kind of tee this up a little bit or set up the situation, smaller clients will probably be less familiar with the post-grant actions. for example, in Brazil. Brazil is a key, as Ludmila had said, a key active agro market for the world, with exports, but not only that, but also as a customer base for many agro industries. But smaller clients might be less familiar and may require more detailed guidance and process and risk, whereas larger clients might be familiar with the basics, but in some cases may have more complicated issues to discuss. Next slide, please. So when looking at explaining your post-grant proceedings to in-house counsel, or if you are in-house counsel, some things to kind of consider and maybe even ask of are, whenever you provide succinct summaries, reporting an opposition or reporting a re-examination, it's key to really detail all of the options to your client. And some considerations of details that you might want to include are who may file the request. Is this a competitor that are they able to file the request? Could it just be an interested citizen? Is the challenger, can they be anonymous? Do I know if competitor X is challenging my patent? Another thing is, do they have to demonstrate an interest? Or like I said, can it just be anyone who, may be a concerned citizen? The other thing some of the other considerations include discovery. Is that available? If they file an opposition, are they stopped from challenging the patent further in other proceedings? And what evidentiary burden is there? In some jurisdictions, we have to engage someone to sign a declaration, an expert. Sometimes they can be an expert from within the company. Other times they have to be an independent expert that we actually hire. The other question are appeals: how, when, and where, and at what step in the process. If we settle the action, let's say it is with a competitor, are we able to stop proceedings? Or if once this proceedings hit a certain milestone, will they proceed no matter what? The other question is, if there are concurrent proceedings, if we had filed a enforcement action in federal court and someone files a re-exam or an opposition, does that somehow stop these proceedings or somehow delay them? The other thing to also know is, who is the decision maker? Is it going to be a board of technically trained people, or is it going to be a judge who doesn't maybe have the specialty within patent law, or maybe doesn't have a technical degree? Is a judge able to hire a special master? Who's going to be our audience in this as a decision maker? And then also time frame to final decision and costs are really, really important, because as a client at the outset, we are going to have questions. This is going to impact our bottom line. And so it's going to be one of those things we need to see, how will that affect not only the budget and our expectation this year, but also our future projections. And then kind of the final two, and this one was a little bit unique in my experience to Brazil, was also the status of corresponding applications. If we do have divisionals, do we have to wait till those divisionals are brought up to the same time frame in as the parent case in order to get a decision? And finally, and I kind of bolded this because every client is going to come to you, whether or not you're in-house or outside, and that is the likelihood of success. And that is one of the things that I know as attorneys we don't like to opine on, but it is always a question we get asked. One of the factors I would say in my experience as asking this question, because I've both been asked and asked it, is give an honest assessment. And as our representatives, we engage our counsel to give us an honest assessment. Sometimes giving us an honest negative assessment is better than a positive assessment for getting our business. If anything, it is being given an over rosy picture is actually a red flag for in-house counsel. Next slide, please. And I do apologize, I'm going a little bit slow here. So when looking at these challenges, in addition to the previously mentioned considerations with the client, other things to consider is, does this cover an existing product? Will this cover a future product? If we're able to determine who filed the opposition, does this create a licensing opportunity? And then also the other question is approval from a non-patent governmental authority. Is this a product that we have in the pipeline that we're just waiting registration? Or is this something that the arguments we present there will also be presented to this other governmental body? So we have to have consistency across, both the IP legal team, the regulatory legal team, the commercial legal team. That is a really key consideration because we want to be, not only are we honest, but we also want to make sure that in those arguments that they appear 100% consistent across the board. Next slide, please. And so some of the challenges that we also get into while arguing in other jurisdictions, that's why we have to be kind of careful and consider what arguments we make, even when it comes to novelty and inventive step. Novelty is somewhat similar across jurisdictions, but there are different methods in determining, for example, whether or not a prior art is enabling, whether or not the prior art actually exemplifies what the opponent says it does, or whether we're the opponent. The other question when it comes to technical arguments, sometimes I have seen in my experience, if we have a decision in one area, that will be leveraged in another opposition in another jurisdiction. This is somewhat similar to what can happen in prosecution. It's been my experience that sometimes in various jurisdictions across the world, they will cite either Europe, the US, or some other jurisdiction that is considered very competent as having allowed the patent, and the examiner will say, hey, well, if you adapt those claims, we will give you a patent. So while sometimes it is more persuasive in prosecution, it can still be cited in oppositions, but my experience has been that typically when you have an opposition or any post-grant proceeding, those are less persuasive, and usually the decision maker will look to their own, not only their own law, but also their own consideration. And so when kind of looking at novelty and inventive step, you also have to look at the varying areas of law. This could include, like Dr. Engels might talk about, list selections or genus versus species. That happens a lot in the chemical space. Method claims, some jurisdictions don't allow method claims for crop protection materials or for chemicals. And so in those jurisdictions, we might have a corresponding patent that doesn't have method claims. And that might come up in the opposition. And so when working with outside counsel from various jurisdictions, you need to be able to explain why one patent in one jurisdiction might be different than another. Also too, again, as I said, those representations to any governmental agency needs to be consistent with the representations that are made both to the patent office and during the post-grant proceedings. Next question, next slide. And so another thing too is support requirements. Support requirements, especially in the chemical space, a lot of times chemical applications can be drafted kind of broadly with like a scaffold, and you might get down to, you might have a kind of a genus, and you might get down to subspecies or individual chemicals. And so there is a big risk across jurisdictions for support requirements. This is a risk to the patent holder, and differing law can result in inconsistent decisions. This could be, adverse decisions that could include preliminary decisions. And like I said, those have been cited elsewhere, or, but typically they're not as persuasive because law across varying jurisdictions is different. And so that is really where, as counsel, you can provide value by being able to cross-coordinate with counsel in other jurisdictions about being able to explain and distinguish those adverse decisions. And then also, while it is somewhat of a slow feedback delay or feedback loop, experience gained in oppositions and post-grant proceedings should inform your future prosecution. And like I had said before, typically we'll look to the stricter jurisdiction that will inform other jurisdictions. So next slide, please. So kind of looking into this, and I will try to hurry a little bit. Considerations with working with clients, like I had said, there's costs, and those can include external of the litigation, so expert fees, filing costs, lawyers' costs, strain on internal resources as well, being able to talk with scientists, depositions, declarations. There are also other benefits. What are the opportunity costs of defending or filing an offensive post-grant proceeding? Is there potential for reimbursement of all or partial of the legal fees? Again, I talked about likelihood of success. Honesty is key there. And then also finally too, there are risks that need to be assessed. Filing an opposition when we have to pay an opposing party legal fees. The other one is reputation as well. Not all of the risks that we need to consider are necessarily financial. When looking at claims that maybe are being opposed or that we want to oppose, would this require us to sue a competitor and or a customer? Would they be claims that, how much value do they bring to the organization that way? Next slide, please. And so with that, some ways that you can really add value are to create some timelines. And with those timelines, really keep it basic and simple to understand, but have key milestones. And those milestones are key because it allows us as in-house counsel to go and set expectation for our decision makers. It allows us to show how this might progress, where we might be able to settle, if we can't settle, when and if those costs might be incurred. So here are just some considerations that I have, but also with that, and this is kind of the last bullet point, include cost estimates in that timeline. Let's go to the next slide. And the reason why costs are key considerations is because often post-grant proceedings and oppositions can get very expensive, over hundreds of thousands of dollars. However, when you tell a client that it might be a couple $100,000, the question is that all at once, or might that be spaced over a couple years? And the key with that is being able to allow them to set their budgets accordingly. And by tying that with the timeline, it can allow them to see when and if major events could be avoided, or when those costs will eventually become sunk costs. And they can also help inform the value of litigation and settlement. Next slide, please. So really, one of the final things I want to kind of touch on is understand your audience when communicating with them. And what I mean by that is typically as outside counsel, as in-house counsel, when you first meet and discuss the opposition, you will likely be talking to another trained patent attorney, at least there. However, often in those meetings or follow-on subsequent meetings, there'll be other untrained decision makers. Those can include scientists, senior decision makers, regional decision makers, or non-patent trained attorneys that might be an attorney who's a representative of that region. For example, if there was going to be litigation in Brazil, there might be some senior scientists, some business regional leaders, and maybe even the head legal manager for Brazil, in addition to the IP attorney being there. So part of that is remember that not everyone will understand everything that is being said, kind of in the patent lingo that has kind of been established, but also often English will be used, but that does not mean it is their native language. And so being able to have that clear, concise communication is key. And also remember that your ability to meet as a huge group will likely be very limited. And so oftentimes senior leaders will be required to approve or deny a decision to go forward, whether that could be an offensive action or something else. And so being able to make the most of each of those meetings is key. And I think that's really where outside counsel can shine. Next slide. What I mean by that is when looking at how outside counsel handles oppositions and the value they bring, kind of by almost sometimes being able to read our mind before we can really influence how we view that law firm. And then also as in-house counsel can really show us how they can help add value to what we do. And so while post-grant proceedings can be complicated, costly, and lengthy, they create uncertainty for the client. And so the more that you can provide those concrete solutions, the better. And it really creates the opportunity as outside counsel for you to shine. Kind of a final thought that way that I missed a little bit on slide 12 was, while we, as lawyers, while it is cool to see new and interesting law change, remember that especially as in-house counsel, what we're trying to do is provide solutions, concrete solutions for our client. And so just kind of remember that in your communications. And next slide. So thank you. That's it for my part of the presentation. There's my contact information if you need anything else. Thank you, Ludmila.
Thank you, Nicholas, for a brilliant presentation. We could clearly see the challenges faced by global companies, not only in prosecuting, but also enforcing and challenging rights in different jurisdictions. Certainly, every jurisdiction has its particularities, and the use of foreign results and case law must be very cautious. At least with regard to the Brazilian practice, I'll add that one significant issue may be that the judges ruling patent lawsuits usually have no background on the technical aspects, or sometimes may have very low knowledge about the patent system, which may be very challenging as they will rely only on the court expert opinion. And also, I'll say that most litigation related to biotech and pharma are under secrecy, so it may be very challenging to have to quote great case laws as well. So that said, now we'll have Dr. Engels' insights regarding the European practice. So Dr. Engels, please, the screen is yours. Would you, Caio is starting the presentation, and you? We can see your screen now. Okay, please go ahead. I think you are on mute.
Okay. Thank you. It's really a great honor for me to have the opportunity to speak here and to provide you some of my thoughts and to make a little bit more particular view on the legal requirements in the European patent prosecution. And I try to do my best to make it quite short and quite easy to understand, because we have several really problems when we get patent applications written outside of Europe, because it is very important for Europe to make sure that you meet the formal requirements. And this is one of our main problems when we get patent applications from abroad. So today I will make the key in the biotechnology area, because I'm a biochemist and I represent usually the technical engineered plants and animals, and further I am experienced in the pharmaceutical area, but today I will make the main points in the biotechnology of agroscience. So our problem here in Europe is how to get new plants protected, and I will provide the opportunity to get this patent protection for plants which are technical engineered, and of plants which have a new key main feature. And we will try to go a little bit in detail. If you have questions, you can ask at the end of the meeting. So it is important that not everything can be protected in Europe. So we have very strict legal requirements concerning the possibility to get patent protection, for example, for essentially biological processes, which is, for example, just usual breeding of plants. Even if the plant has a particular feature or a particular trait, it is not allowable to make patent get patent protection for just a process where you breed plants having these particular traits. But what we can get as a patent protected is, for example, if you have new nucleic acid sequences, vectors, or shuttle systems. For example, you have a new clone of a plasmid, and this is providing particular features to the plant. You can protect the sequences as such, and the system where you can make the technically engineered plant, and you get the plants as such if the plant has a clearly differing technical feature, which is, for example, a new gene introduced by, so artificially introduced by a particular technique, or you can get the cell or cell plant part, which is engineered and it is not naturally occurring. So furthermore, it is allowable if you have plant products which result from a plant having the particular feature, but it is necessary that the plant product itself differs from any plant product obtainable from plants which are non-technically engineered. So it is necessary in in Europe as well, that you have a clear differing technical feature, and it is not allowable to make usual naturally occurring processes and naturally occurring plants. For example, if the plant is obtained by a non-essentially biological process, it is not allowable to protect the plant as long as the plant as such is not differing from a plant which is naturally occurring. So this is necessary to know that the product by process claims, so a plant produced by a product, by a process which is as such grantable, the plant is not grantable if the plant does not include any feature differing from a naturally occurring plant. So what I want to make clear is that we have several formal requirements which are very necessary to meet in Europe. And then we speak a little bit about patentability requirements, which is novelty and inventiveness. So the legal requirements, the formal legal requirements are very strict in Europe. So we have to make sure that the legal formal requirements are met. Even if the product as such is novel and inventive, I cannot get it granted as long as I don't meet the formal requirements. And one of the important formal requirements is the sufficiency of disclosure and the enablement disclosure. So we have, I said it before, we have the possibility to get anything granted which differs by a technical feature. So we have to make sure and clear that the technical feature is included in the claim. So if, for example, I have a plant and the plant includes a new gene or has a particular mutation or has a substitution in the sequence, then we can define the plant by this technical feature. But you have to make sure that the new products which are described are so described that a person skilled in the art can obtain this product. So if you have a possibility, not a clear possibility to describe the technical feature, then you have to provide any possibility to obtain the product you claim. So for example, the description can contain a process for preparation. You can provide the cloning steps, the plasmid cards, and this is very important if you have any mutation or reconstruction of genes or something else, you have to provide the sequence. It is very important in Germany that you provide the sequences and the sequence protocol, which is clearly needed. If you don't have it, the application is not supported in a way that a person skilled in the art can carry out the invention. So if you have no possibility to clearly make the description of the new prepared organism, there is a possibility to make a deposition of the biological material, which can be seed, which can be a microorganism. If you claim a microorganism, for example, you have the opportunity to make a deposition, but then you have to make sure that the material is deposed when you file the patent application. The data of the deposition you can file later with the EPO, but you have to make sure that the material is first deposited and then you file the patent application. One thing we really highly recommend to have in the description is examples or data illustrating the invention. Otherwise, we have very often the possibility that the examiners say, we are not sure whether this really can be carried out, and then we have a problem with the support and the sufficiency of disclosure. So therefore, please, as far as possible, please include experimental data in the description. So another formal requirement, and this is very strict concerning to in comparison to the other legal requirements in the other countries abroad from Europe. It is very important that you define what you want to say, because the European examiners, it's quite it's a little bit funny, but it's quite pity. We have so many countries in Europe that not all the European examiners speak the same language. They should at least, all of them should at least speak English, but sometimes as well the English language is not very, very good. So we have Greek and Italian and Belgian and Turkish and several examiners, and therefore we have to make sure that they read and speak the same language. Therefore, we have very often the objection for very common technical terms. Thus, it is very recommendable to have definitions of the terms in the description of the patent application. So you don't have to explain the very, very basic things, but it is better to define a little bit more than to define less than you use. Further, it is not recommendable sorry, why I don't speak about Germany. So it's in Europe to have these relative terms like about or almost or essentially without defining what is meant with about. So for example, if you have about, you can define with about means it is almost 98% like the term I use or something like that. So you just have to define what is meant with this at least a little bit unclear definitions. And then we have the possibility, the problem with the examiners at the EPO, that they often object to broad claims. So if they have the possibility to object them due to decrease the workload for searching the claims, then they do that. So we have to make sure that we define what is meant so that the examiners cannot say the claim is so broad that we cannot search it. So defining the definitions in the claim has the advantage that we can define that the examiners have to make sure that everything which is falling under the definition of the claim has to be searched during this or considered in the search report. So for example, if you have only a very broad definition of, for example, what an enzyme should do, so for example, an enzyme making a new gas, then you have to define really what type of gas is made or something like that. So it is, you have to make sure that it is supported and it is clear what enzyme is meant. And at least you have to show the sequence of the nucleic acid sequence or the protein sequence, so that it is clear what is meant with the enzyme. But this broad claims, we very often have the problem that the examiners don't want to make their work and they don't search the full broadness of the claim. Then if they don't make the search, they restrict your claim to what they searched. It is a very uncomfortable situation for us because the examiner decide what they search and we have to live with their decision. Therefore, we try to make sure that the claim is as clear as possible and as broad as possible. But we have very high struggle if the examiner decide we just search one particular embodiment and all the other embodiments are not searched. Then in the worst case, we have to file a lot of divisional applications for the unsearched subject matter. So now my very favorite legal requirement is discussed, because this is very, very different compared to other countries, in particular compared to US. The original disclosure. The original disclosure in Europe is it is only disclosed what is literally disclosed in the description of the application as filed. So the European examiners are very experienced to make objections against original disclosure if you only use one differing word from the original disclosure. So make sure that you write what you want. So it is really an absolute horrible situation if you cannot provide original disclosure for what you want to claim. So therefore, we have several recommendations. For one recommendation is don't describe independent embodiments in your description, because if you describe independent embodiments, you are not allowed to combine features of one embodiment with features of another embodiment. So please make sure that the original disclosure is written in a way that according to the invention, we can have this trait or this feature in any of the embodiments, or we can provide the combination of features by describing in an aspect of the invention, we combine this feature with another feature, or in a further aspect, all of the features provided above can be combined, or something like that. So one possibility to make sure that you can combine the feature is you include in your description aspects of the invention in a way like multiple dependent claims, but it is not written in a further claim, but in a further aspect of the invention, you can combine the aspects 1 to 5 or all the other former aspects or something like that. Like a claim formulation, but just formulated as aspects of the invention. This is very helpful in Europe because in that case, we can combine all the features of the aspects which are provided like a dependent claim. So, and multiple dependency is allowable. So this is my high recommendation to make sure that any feature which should be combined is disclosed as combinable in the application of a file. So one further thing is avoid a selection of lists of features. So if you make for example, any alcohol can be ethanol, methanol, propanol, and so on. And you have another list where it is written the buffers can be A, B, C, and D. And you nowhere write that it is particularly mentioned, or nowhere is particularly mentioned or preferred that the alcohol should be ethanol and the buffer should be A, and these can be in one embodiment, then you have a problem to select this particular feature from a list. So all these things we very often have with US patent applications, which are written under a different focus. And then in Europe, we have the possibility we have no possibility to combine the features. This is really a pity. So sometimes everything is written in the disclosure, but we cannot combine it. That is really not the best situation for us. So the formal requirement of the original disclosure is further very strictly considered during opposition procedure after grant of the patent. And then if you have no original disclosure to amend the claim, or one of the opposition reasons is that it is not originally disclosed as it is claimed in the granted claim, then you really have a problem, because during the opposition procedure, the EPO is absolutely not less strict as compared to during the prosecution, but it is considered with a sharper sword in the hand. So it is really very, very necessary that we make sure during the prosecution and before grant that everything we claim is originally disclosed in combination of the features. Please be careful. So now we come to the patentability requirements, which is novelty and inventiveness. Everybody knows that. But now we come again to the very strict focus of the EPO concern, or in comparison to the other jurisdictions. In Germany.
Sorry, Barbara, just to let you know that you have 5 more minutes.
Sorry?
Just to let you know that you have 5 more minutes.
Okay. Yeah, okay. I will make it sure. Novelty is usually everybody knows if something differs from the prior art, it is novel. But in Europe, it must be very clear what is differing from the prior art, and you have to make sure that the differing feature is not unclear. If the differing feature is unclear, the examiners don't consider the unclear feature, and then you have no novelty providing technical feature. So therefore, make sure that what you make the differing feature is clearly defined. So that is the main feature of a novelty. So for examples, in plants, you have a mutation or a not naturally occurring gene or a new combination of genes. Everything of that is clearly novelty providing. So whatever is differing should be clearly defined. Then in Europe, we have the problem solution approach to consider inventiveness. And the problem solution approach means that the differing feature providing novelty should provide any particular difference, not only an advantage. If you have an advantage, it is clearly inventive, but it should be at least a clear difference, and the difference should provide any possibility not obtainable by a plant which does not comprise the differing feature. So the problem solution approach is the main approach according to Europe patent prosecution to argue inventiveness. And sometimes the inventiveness is a feature which is in the mind of the patent attorney. So if you can argue clearly an advantage provided by the differing feature, then you get a patent granted, even if it is almost clear that this can be provided by the prior art as well. But if you provide a good argumentation, it is possible to get inventiveness. But my recommendation is something should be written in the description what we can use to argue the inventiveness. So just shortly, the plant breeding processes are not patentable, But if a process has an artificial technical step comprised therein, and this artificial step makes a new trait or feature for the plant, then this process as well is patentable, because the technical step provides the necessary technicity for the process as well, and then you can get the patent, the process granted. So as I said before, this plant cell or plant part should comprise a technical feature differing it from a naturally occurring plant, and therefore please make sure that we can define the plants by the technical feature. So very shortly, it is not allowable in the European prosecution to get a plant variety granted. This is an exception in legal requirement of the EPO. And therefore, there is a possibility to have the plant variety protection by other ways, for example, by German national law, or by an organization which is responsible for providing variety protection. Just to mention that we have to provide several information about the plants if we want to make a plant variety protection. But this is not allowable under the European patent law. Thank you for your interest. I hope that this was quite informative. If you need more information, you can contact us. We have a webpage on F&E patent. If you have questions, you can contact us directly. Thank you for your interest.
Thank you, Barbara. Thank you for sharing your EP view. I'll say that it's very important to us to know about the different aspects of the EP practice, since we often see that the PPO tends to follow the EP practice, and also because despite we do not only prosecute in Brazil, we usually have to go abroad, so we always seek protection in the US and EP. So it's very important to have this in mind in order to, when we are drafting a patent application. So now on the other end, we'll have Dr. Romano insights on the challenges involving the emerging technologies in the US. So please, Charles, the screen is yours. And Kyle will share your presentation.
Well, thank you. And thanks to the other panelists for doing a beautiful job of setting up what I'm going to talk about, which is one particular new emerging technology, which is plant gene editing. So I just want to briefly mention before going on that there are, of course, a lot of emerging technologies. And one that I think has a lot of parallels to this is in the area of biologics, which are using microorganisms in crop improvement. Of course, as well as sort of the whole data acquisition, artificial intelligence area. And we're going to focus on gene editing. Next slide, please. So the goals of the talk are just to really go over, so we're all starting at the same place, some of the key advantages to gene editing, and then to move on to a discussion about what sorts of patent protection are available in the US. And then with the help of some of the other panelists, as well as Ludmila, I'd really like to sort of compare and contrast what the situation is in this country, in Europe, and in Brazil. Next slide, please. So what I really want to point out with this slide is that this is not something that is a dream or a hope. This is something that is here now, and I have a picture of a product that's currently being marketed in the United States as a direct-to-consumer product, which is a healthy soybean oil, which carries a premium. So in addition to improved agronomic traits we're all sort of familiar with, herbicide, disease resistance, stress tolerance, It's also going to be very, very useful for getting improved feed and quality traits. So next slide. Thank you. One of the key advantages as well is that it has the potential to really accelerate breeding. So we can now make very rapidly targeted genetic changes in plants. And those changes can be the same as the changes introduced in breeding or nature. And in this regard, just to help everyone think about this, the best analogy I've heard of is if you think of the genome as a book, in the past, what we essentially had was a word processing program that had just one function, which was a random insertion function. And we did a lot with that. There's some breakthrough products for herbicide and insect tolerance. But we now have is actually a tool which allows us to specifically change individual letters in that book, individual sentences, where we can target changes very specifically and make even single base pair changes in genes. So next, this just sort of illustrates a typical classic breeding pattern in rice, where multiple traits were introduced through conventional breeding. And what I think you can see, don't worry about the details, is that it took basically about 4 to 5 generations in order to bring all those traits together in one rice plant. And now with the new technology, we have the potential to bring together multiple traits in 1 or 2 generations. So I think it's pretty evident that this can have a big impact. Next slide, please. So the other key feature to think about, and you note that I'm saying potentially, is that there looks like there could be potentially lower regulatory burdens. So I just sort of tick through some of the countries, Argentina and Brazil, where it's going to be case by case, but it's potentially non-GMO. In the United States right now, there's still a little bit of flux, but the current posture is one where if the product that's made by gene editing is something that basically is not involving insertion of a new sequence, but is something that could have occurred through breeding or in a natural gene pool, that this is something that could be potentially exempt. So cautionarily, though, I just wanted to point out, Europe, as it stands right now, plans to regulate gene-edited crops as GMOs. We're still waiting to hear about what's going to happen in Russia, India, and China. And so this is evolving and something that everyone's going to need to continue to monitor. Next slide. So as we all know, just intuitively, and I just pulled together a few graphs to show this, major companies like Corteva, Syngenta, Bayer, they don't invest lots of money in research and development unless they have some hope or potential to protect that. And this is a very simple graph that just sort of shows the publicly disclosed R&D budgets for these companies, and you can see that it pretty much mirrors the patent applications that they file. Next slide, please. So we really then come to the question, what I want to address today is can we obtain meaningful patent protection for something that in many cases could have arisen through conventional breeding or naturally? And again, Barbara, I think, set this up really brilliantly with her slide where she talked about how if something is old, but it happens to be made by a new process, that isn't enough to distinguish it. It's still old. It's still something that occurs in nature. And then, please, if we go back to the previous slide, please. There we go. The other point is when the use and breeding of the plants after you've made the edit is something that is just an essentially biological process, what can you do to protect that sort of activity, if anything? Or the products themselves, if they're only distinguished by the presence potentially of edited DNA, is that something that's at all protectable? Next slide, please. So now I'm going to just sort of focus in a little bit on gene-edited plant utility patents in the United States. And I know the common perception is that we can patent everything in the United States. So there were a lot of things we can patent here, we can't patent elsewhere, but it falls a little bit short of everything, as we'll see. So we are blessed, as is Europe, that we can patent the genetically edited plants and seeds, so long as they meet the other criteria. Even plant breeding and plant cultivation methods are potentially patentable, and those can be quite useful claims. And food and feed itself, again, if it meets all the other criteria, being novel and inventive, is potentially patentable. Next, please. So, just as I mentioned, there are some caveats. Of course, has to meet novelty inventive step. But as all of you have followed US patent law recently, and particularly, I'm sure you've been getting nervous when I've talked about how it's something that could have arisen in nature. The Supreme Court has said that if something is just directed to a natural phenomenon, that it's not patentable. That was the Myriad decision talking about isolated DNA molecules. However, if the claim doesn't pass that hurdle, the next hurdle, or the way that it can get through to being patentable, is if you can demonstrate what's called the markedly different characteristics and having some sort of potential or significant utility. This is another landmark Supreme Court decision. So next slide, thank you. So one of the points I think is really critical here and very important in people framing this to the Patent Office and other agencies, as Nick talked about, very important to be consistent. We're going to come back to that, is the simple possibility that something might occur in nature doesn't mean that it's a natural phenomenon. And the Supreme Court actually was in a footnote, but they sort of spoke to this in Myriad, where they said that the mere possibility that it might randomly occur does not make it unpatentable. And there's even some guidance that the Patent Office has provided to the examiners in thinking about subject matter patentability that backs that up. So I think the one thing to remember is that if a plant or a seed with a gene edit which doesn't occur in nature but might occur, this may be something that's patentable, at least where the courts are standing now. Next slide, please. So again, on this issue of these sort of patentable subject matter obstacles, this first bullet up here is actually pulled from the Code of Federal Regulations, which is talking about what some of the criteria are that would make a gene-edited plant exempt from the sort of regulatory burden that's present for a genetically modified plant with an insertion. So what it says is that if it introduces a gene known to occur in a plant's gene pool, or it makes changes that correspond to a known allele of a gene or a known structural variation present in the gene pool, that this would be something that would be exempt. So if we think back to that other slide where I presented from the rice breeding, if someone went ahead and made the rice with those same known alleles of the gene, and they pulled those together, it may well be exempt, but it would certainly face some patentability challenges. First, under it being not novel and obvious or lack inventiveness. And then certainly, it's also going to face some patentable subject matter challenges. So, what may be left for those types of plants that sort of have all of those features would be perhaps if that was made in some sort of unique germplasm that differed from an existing variety, there may be available protection as a plant variety protection certificate from the U.S. Department of Agriculture. Less desirable than a utility patent, but certainly better than nothing. Next slide, please. Great. So just to summarize real quickly, just want to let everyone know that just because something might occur, that it's a possibility, that's not sufficient for the patent office to deem it a natural product. They really would need to show that it in fact does occur in nature. However, that any sort of gene edits that correspond to known mutations are going to face a number of different challenges in the US. Next slide. And really sort of overlaying all this, and this really gets to some points that Nick made in his slide, is it's absolutely critical that consistent, accurate, legal, regulatory, and marketing statements be made by everyone in the organization. What I can tell you, and it's become very clear now. In fact, there was just a case involving a drug decision before the Federal Circuit Court of Appeals last week, where if you make a statement to a regulatory agency, and that is held as an admission about something you're trying to patent, that's something that can and will be used against you by the U.S. Patent Office, or if not the U.S. Patent Office, someone in a post-grant of proceedings or in court. So just finally, to emphasize that point, got a little graphic here. Next, please. So just want to make sure that all those things need to be the same. Great. Next slide. So just going to transition very briefly here to the gene plant product utility patents in Europe, where we have a situation where the genetically edited plants and seeds, if they meet all the hurdles for patentability, at least have the potential to be patented. As Barbara pointed out, something that is solely drawn to plant breeding and cultivation. It's even if it has been done with something with a patentable gene edit in it, is going to be deemed to be essentially biological process, not patentable. Also, food and feed, and Barbara can certainly discuss this later. If it's only distinguished by the presence of the edited DNA, and that DNA isn't something that's sort of conferring a technical feature on that feed that distinguishes it, you're going to have difficulty patenting that in Europe as well. So then just to shift gears, thank you. Next slide, please. Brazil presents even more hurdles. So as everyone knows, plants and seeds are simply not patentable subject matter in Brazil. There are also prohibitions against patenting methods. Now, what that leaves us would be the possibility of having some sort of a method claim with this type of technical step that Barbara talked about for making the plant. But unfortunately, while this may preclude people from actually doing those types of steps in Brazil, that's not really going to be the bulk of the sort of useful claim because seed sellers, users, people who might use the seeds in a manufacturing process, they're not going to infringe that claim because they're not going to perform that technical step. So really then, I think one of the things we could discuss perhaps later, and would love to hear Ludmila and others comment on this, is the possibility of patenting a non-regenerable food or feed, such as a seed meal that's distinguishable and meets other patentability requirements, or the possibility of getting a claim around a food or feed manufacturing process. So next slide, please. Just what I want to leave everybody with, particularly anyone in business and law and science, is that ag innovation is absolutely critical, and patents are important for supporting research and development and advancing ag innovation. We're not going to get to where we need to be without innovation like gene editing and biologics, the whole, as well as really applying big data to solving ag problems and delivering solutions. So, this is an area where we need this kind of work. Encourage everybody to get involved in working in ag. And I'm going to leave it there with just a couple final slides. Next, please. Thanks again. This is just sort of a picture of what you might see not too far away from where our law firm is located up in Des Moines, Iowa, and where Corteva has a major presence, former Pioneer Hybrid site. And then that's the pretty picture. Just going to finish with the last slide they make me put up. Just sort of the disclaimer that these are not legal advice, as everybody knows, but hopefully it'll spur some discussion, and look forward to, that's the end of my presentation, and we can shift to the panel and look forward to some questions.
Thank you, Charles. Thank you all for all the brilliant content. So just taking Charles' cue, I'd like to start the discussions on the topics raised in his presentation. So as the Brazilian practice, as mentioned by Charles, genetic engineered plants and seeds are not patentable. So according to the Brazilian IP law, the all part of living beings, with exception of microorganisms that meet the 3 patentability requirements, are not patentable as well. So plants and part of plants, such as in Europe, for example, seeds and plant cells are not patentable even if they are engineered. However, plant varieties which are distinguishable from other plants as they occur in nature may be protected by a sui generis rights, so-called cultivar. So cultivar are controlled by a division of the Ministry of Agriculture, Livestock and Food Supply. And the term of protection is of 15 years, except for vines, fruit trees, forest species, and ornamental plants. So which protection will last for 18 years. So to have these varieties protected, they must meet 3 requirements. There will be distinguishability, homogeneity, and stability. So even that they are not protected by patents, we have a tool in Brazil to protect this kind of invention. And as to plant breeding and plant cultivation methods, as you already point out, Charles, if they are referred to natural biological process, they are not patentable, which means that a process that occurs spontaneously in nature and which human intervention does not affect the final result are not deemed patentable. But on the other hand, if you have a process involving the crossbreeding of genetically modified plants that resulted from direct human intervention, they may be eligible for protection. So methods are making plants by gene editing that requires human intervention and also are also eligible for protection. And also the tools used in such methods as the gene constructs and vectors. So with regards to food and feed, this also may be a strategy to think about when you are drafting your application. Food and feed, the discussion we have taken already also applies to food and feed. So if they are substantially just the food is made of a special species as occur in nature, they cannot be protected. But or if they result in a mere dilution of this contact, they are not considered. They are not eligible of protection as well. But if you have a product that involves human intervention and involves other content that are not found in nature, they can be protected. The same will apply to process for producing this processed food and products. If they, again, are not a mere dilution and involves human intervention, they can also be eligible of protection. So this will be what I'll add to Charles. We have very similarities with the EP practice where you cannot protect products and even process as they occur in nature. But if you have a human intervention that will affect the final results, they may be eligible for protection. And Barbara, in the same sense, would you like to, do you have further comments on the points raised by Charles?
In Europe, we have to make sure that we meet all the requirements. We have guidelines where it is written what is allowable for claims or not, but the guidelines have been amended during this year, and we have some requirements included in the guidelines which were formerly not included. For example, priorly, it was not possible to make sure that if you only have a smaller amendment in the sequence, that you can claim it because mainly or very often the examiners said this is naturally occurring. And now we have included in the guidelines, for example, that we can claim the smaller sequence amendment by making a disclaimer saying it is only an artificial mutation, not a naturally occurring mutation. So only if the plant is changed by really a biotechnology technique, then it is claimable by defining in the claim that it is not a naturally occurring mutation. Further, we can make clear in the claim that a plant only made by a technical procedure, including a particular change in the sequence, for example, a new promoter for gene translation or something like that. This can be claimed particularly in the claims, and sorry. And therefore, we can restrict our claims, but it is not really a restriction because we only define that it is artificially done or it is not naturally occurring, and then we can get the plant or whatever granted. But for example, the food and feed, we have to make really sure that the food or feed differs from other naturally occurring food or feed by a technical feature. So, for example, it is not enough that it is just a higher oil content or something like that, because this is naturally occurring as well. But sometimes it is allowable by defining that a particularly amended enzyme is contained in the food or something like that. This is grantable, but it is improved, according to my opinion, in the guidelines to make sure that there is something patentable in genetically engineered organisms, plants, microorganisms or such. This, according to my view, is a clear improvement in comparison to what was formerly only just made like a decision from the examiners.
Okay, thank you. Nicholas, would you like to add something to Charles' presentation and the topics raised?
Just kind of, with Charles' presentation, I come more from the crop protection or the chemical side, but a lot with what he said, especially with about how innovation in ag is really protected and driven by patents, I think is key both from the biological side as well as from the crop protection side. And while there are varying degrees on what is allowed, whether that could be method claims, whether it could be gene editing claims or plant claims, although jurisdictions might differ, the key thing with the patent protections that are out there is being able to tailor that to your client and protect what they would ultimately want to do. And there's a variety of ways we can do that. But because of the varying jurisdictions, oftentimes what we need to do is meet with some of those key agents, whether that be in Europe, the United States, or Brazil, or other jurisdictions, and really kind of tailor our advice to that. That's kind of where I would have to kind of add kind of my 2 cents there that way. And oftentimes too, just one more thing is kind of like Charles had said, historically a lot of the traits would go hand in hand with pesticide. So that could be an herbicide or insecticide, or could offer the plant some protection against some of those materials, which allowed farmers many useful tools in, that could be corn, soybean, other crops. And so part of the key there too is sometimes you will have to not only get cross-jurisdictional, but cross-technology cooperation, both with the chemical side and the biotechnology side as well.
Awesome. So we have a lot of comments by the audience. Congratulating you, on the presentations. And we have a question here for Nicholas, but also if Charles would like to comment, please be my guest. So in Brazil, the divisional application cannot refute the same invention, and she only claims subject matter not included in the paired application. Is there any difference in the concept of double protection with regards to divisional applications between the US and Brazil?
Yes, the short answer is yes, there are many. So in the United States, when we talk about double patenting, we kind of refer to 2 types. One of it is statutory, and the other is non-statutory or judicially created obvious type double patenting. The issue that you can get there is in the United States, if you have a patent application and that patent application has a restriction requirement and you file a divisional application, what that does is by filing the application and designating it as a divisional, you stop or you prevent the patent office from coming back and saying there's a double patenting rejection here. But however, if you file it as a continuation, you're not afforded that legal protection. And what that does is it prevents the patent office from saying, we want double the fees because we want you to split this application into 2, and then coming along later and saying they're the same invention. In the United States, the double patenting restrictions and requirements are a lot less than in other countries, such as Brazil. I would also think Argentina. They're much more lax. And sometimes what that allows us as US practitioners to do, I would even say we're probably a little bit more lax than Europe, but I think Europe is a nice kind of middle ground that way. Barbara can possibly speak to that. But especially with the obvious judicial type patent application, we have some other tools that we can reach into. One of those is being a terminal disclaimer. If the patents are going to be co-owned by the same entity, and that's key. Co-ownership is key, and that is a legal determination that you need to, reach out to your U.S. counsel. But basically, as long as they remain co-owned, and you don't mind one patent expiring at the same time as the, primary or first patent, then you can file what's called a terminal disclaimer and can easily get around that objection. But in the US, it is a lot more lax for us. And because of our support and written description requirements are a little bit more lax than Europe and some other jurisdiction, that gives us that gives a US practitioner a lot of tools in their tool belt to overcome those. For example, when I think of patents that I prosecuted in Brazil and the US, it's a lot easier to get a variety of protection and multiple patents out of the US, but then be restricted to only one in Brazil. And I think that's also a key when working with Brazilian practitioners as well, is sometimes we will have a patent in the US and Brazil will say, hey, can we adopt this? And a lot of times it's like, yes, but we want to file a divisional application to cover the other stuff that we carved out just to get quick allowance in the US. And the key is working with the Brazilian counsel to make sure we can do that, because oftentimes we can't.
That's very true. And Charles, would you like to add something?
Just Nick did a great job. The one key difference that it comes to mind for me, and you can probably better comment than I on this, Ludmila, is that my understanding in Brazil and what I've experienced is that it's very critical at the time of requesting examination in Brazil that you have the full complement of things that you might want to claim in Brazil. As Nick alluded to, while as long as it's somewhere in the specification, you may not be able to get a divisional if it wasn't part of a restriction, but you could certainly go back and claw that other subject matter out later on, perhaps as your products are developed, and that's very helpful. But in Brazil, you're going to be locked in to the set of claims that you request examination on. So that's something for people to be very keenly focused on.
Yes, absolutely. We have this restriction in Brazil that differs a lot from the other jurisdictions. So you have to keep in mind that after you request for examination, you cannot include a new category. You cannot bring information from the specification if it's exceeding the matter that was claimed at the time of the request for examination. So sometimes we go to a very tricky situation with our clients because they do not understand why we cannot include matter after the request for examination, even a divisional, because this restriction also applies to a divisional that is filed after the request for examination of the parent application. So it's something that we have to keep in mind, definitely. So we are running out of time, but I think I have time for just one question for all of you. So I'd like to ask you, what challenge do you think we may face when protecting agro-inventions involving newest and emerging technologies, for example, CRISPR and AI in your jurisdictions? And for Nicholas, which acts globally, what do you think that you may face when we work with in different jurisdictions as Brazil, Argentina, etc.? So please, Nick, if you want to go ahead first, and then we can go to Barbara and Charles.
So one of the first things, and I guess this kind of goes back to my slide 12, especially when interfacing with clients, remember, we're looking to our counsel to provide solutions, right? We're not necessarily looking at being legal trailblazers. We have a business problem. We have rights that we want to secure. So there are certain key areas with innovation like CRISPRs that provide wonderful opportunities for us to further our technology and ease R&D. With the counter with that, for example, with AI, some jurisdictions, like I believe South Africa and Australia, have recently allowed it. That's great if you have some AI inventions. However, we also have to look at some of our very key major markets, such as Europe, the United States, Brazil, and Canada. In the United States, on September 3rd, there was a federal judge at a district court that affirmed that AI is not an individual and is not patent eligible. And so while we kind of, I keep talking about, we like to look at the most restrictive key market, and that's one thing that we have to kind of keep in our consideration. While yes, it is great to adopt new technologies, we also have to look if a key innovation, let's say for the United States and Brazil, came out of there and maybe Europe, we might be able to get protection in Australia and South Africa, but would that be worth it giving it up in some of these other key ag markets? And so like Charles had alluded to before, patents are key in allowing companies to recoup their research and development costs, which are not insignificant. When we look at actives, at least in the chemical space, those can cost hundreds of millions of dollars through the R&D process and regulatory process to bring to market. And so while certain things like digital and drone provide key opportunities to allow us to bring, when we look at chemicals and crop protection, to our customers in different ways and offer varying solutions that can be customized to each farmer. We also have to take a step back and look at the patent laws, and a lot of times laws take a while to catch up with technology. And as attorneys and agents for your customers in those key markets, being able to provide that advice that, hey, there is a lag in the law sometimes with technology, and being able to kind of foresee, the next, 10, 20 years is critical.
Okay, thank you, Nick. So please, Barbara.
Yes, the problem in Europe is that we have a very long prosecution procedure. Usually we have much longer time to get the patent granted than in other jurisdictions, because the European prosecution allows to slow down the prosecution time, and therefore, according to my view, it will be a little bit, or it will take a little bit more time to get a clear jurisdiction concerning the new proceedings and the new techniques. According to my view, the CRISPR-Cas procedure is very well known now, and it is difficult to get it granted in any new way, because now it becomes more and more state of the art, and it is not very particular to make a new plant or a new organism by CRISPR-Cas, and therefore we have a gap between the development of the procedure and the patentability of these new techniques, because due to the very long time usually you need to get a EP patent granted, in particular if the technical area is a little bit special. We will have a clear jurisdiction not within the next 2, 3, 4 years, but we will take more time to get a clear and unambiguous legal case law allowing or not allowing these new techniques. And according to my view, this is a little bit a disadvantage in the EP procedure, because we, until it is an unambiguous case law, we need at least 2 or 3 decisions of the enlarged Board of Appeal, and this will take a lot of time But I'm very helpful that they will allow new techniques, because it is really a great tool to get new developments. And I'm hopeful that also in Europe it is allowable to make an artificial procedure, even if it is involved with an AI.
Thank you. So please, Charles.
Sure. I think clearly the biggest obstacle I see is patentable subject matter. This is both for gene editing technologies, biologics, and I also, from my colleagues in the computer electrical engineering space, anything involving sort of data science, AI. And part of it, Barbara talked about lack of clarity in Europe and development of case law. I think we certainly face that in the United States as well. Our Congress has a few members who have talked about introducing new legislation to help clarify what is and what is not patentable subject matter. That's going to take a lot of time. And until then, I think, in getting to Nick's point about being pragmatic about this, I just think that when we need to draft, we just need to sort of look ahead and think about what all the potential outcomes might be and try to draft claims that are going to cover all of those possibilities. That's not a great answer, but it's, I think, the best we have under the circumstances.
Sure, absolutely. Well, we have also another questions, but due to our time restrictions, I'll have to send you the question by email. It's a question from Gabriel de Blasi, our managing and founding partner. So I'll send them to you, and if you can address it later, he'll appreciate it a lot. So I believe that we could spend the whole day speaking about patents and other issues that are very interesting and exciting for us, but we have a time restriction. So if you like to address final comments for closure, please go ahead. Charles, you're already with your mic on, please.
No, nothing further. Great conversation. Learned a lot. Really appreciate everybody's feedback, and look forward to getting the other questions we weren't able to get to.
Okay, anyone else? Barbara and Nicholas?
I just want to say thank you for the opportunity to speak with you. It was really a great pleasure for me to have contact with you and to share the consideration of the different procedures. And yes, thank you very much for joining. And yes, I'm very happy about that.
Yep, as well, just thank you. It's been a pleasure and a wonderful learning opportunity. I enjoyed it much. Thanks.
Yeah, so thank you very much for being here with me, having this amazing discussion. It was also very, very enlightening for myself. And we hope that we could continue this talk later and discuss other topics. Barbara, it's a really pleasure to meet you. I already have met Charles and Nicholas in the past, but I believe this was a great discussion. And thank you all for being here with us and for joining us in this webinar. Okay, thank you and see you soon.